For your attention. I will now turn it over to the presenters.
Well, hello, everybody. This is Judge Rosemary Collins, recently retired judge presiding in the 17th Judicial Circuit as the head of the Family Division and of the Domestic Violence Division. We're really excited to have you with us here today. This legal protections when child victims are immigrants is one of the first times that we've actually had a webinar that's just devoted to children's issues and how they affect the courts. So it's exciting to be here with you, and I thank you for your time.
And
Leslie?
My name is Leslie Orloff. I am an adjunct professor, and I'm director of the National Immigrant Women's Advocacy Project, American University, Washington College of Law, and I will be joining Judge Collins today in this presentation.
Great. So what we hope to accomplish here today is that we want to make sure that you are able to identify what the different forms of immigration relief that are available for protection of victims of child abuse and neglect victims, and also what might help their non-abuser parents as it directly relates to their children. We want to make sure you know how orders should be done to make sure that the best interests of the abused and neglected immigrant children in custody are reflected, and that also includes orders for protection orders, child welfare, and child support proceedings. We want to make sure that you know what you need to have in the orders to make sure that your decision is reflected in your orders. And we want you to understand how to use the tools that are available that will help you determine which publicly funded benefits and services are open to the abused immigrant children and their protective parents. So it's a lot to cover in about an hour. So we're going to move pretty quickly through these materials. Before we get started, could you let us know who is with us on this webinar? Just write in there, check the box so we know who we have here with us today.
We're seeing it's looking like we have a number of victim advocates, attorneys. For the people that are other, could you write in the chat box where you're from? And I see there's about just under 50 of you online, so it'd be good to get used to using the chat box and to responding to the poll. Great, so that gives us a picture. We've got victim advocates, we've got attorneys, hopefully, and then this is also going to be geared towards judges and court staff. There were a lot of people who signed up who may not be able to attend exactly at this time, so we're going to make it relevant to all of those audiences. And it looks like we have people from adult and child protective services online with us, and people from the healthcare community, victim advocates. Great. Okay, so to get started, one of the things what we're going to be talking about, and one of the most important things to understand, is that whenever you have an immigrant, you have child abuse, child neglect in a family, and you have the child is either an immigrant or they have a parent who is the parent who's trying to assist and protect them who's an immigrant. If you have facts of child abuse or child neglect, chances are the victim and their parent, who may be an immigrant, will qualify for one or another form of immigration relief. And what I'm showing you now is we call it the shield, and it is...
I call it the magic shield, Leslie.
Okay, thank you, Judge. And it's a really good tool to have if you're a court in the Know Your Rights section of the materials you hand out at the courthouse. And it's a really good tool for all of you who work with immigrants, however sophisticated you may or may not be on these issues, to quickly identify which children and which parents or which crime victims may qualify for immigration relief. And it covers each of the major forms of immigration relief that is available to crime victims, and many of which we're going to cover in detail in this presentation. We're going to focus specifically on VAWA self-petitions, U visas, and special immigrant juvenile status, which are the primary forms of relief that people may, children and victims may, and victims of abuse who are adults may qualify for, who may be parents. There also are remedies for trafficking victims. We're not going to focus on asylum because that is much less available and common in the cases you're going to see. Although we can, if you have a case, you can call us, as with any of these, for technical assistance. And at the end of the presentation, we'll have our numbers available where we can help provide technical assistance to courts, to police, to prosecutors, to judges, to advocates and attorneys working with any of these immigrant children who may be victims of that qualify for one of these forms of immigration relief. So what's important to understand is that SHIELD was developed by the Department of Homeland Security, and the Department of Homeland Security has multiple roles, and one of their roles as a matter of statute is to protect crime victims. And to protect, and those crime victim protections extend to victims of domestic violence, child abuse, sexual assault, stalking, human trafficking, and a range of other criminal activities that we're going to show you when we talk a little bit more about the U visa. We also are happy to report that there was a confirmation in April of 2019, very recently, that the DHS victim witness memo is still in force and effect, and they're still operating to try to ensure that victims get connected with the forms of immigration relief they qualify to receive. And that related to that, we'll talk a little bit more about Violence Against Women Act Confidentiality, which is the only form of immigration, the only immigration statute that offers formal protection against deportation to anyone at all, and the people that get that deportation protection are crime victims, and that would include immigrant victims of child abuse. So what happens is that if you go back again and think about, let me just show it to you again, the SHIELD, whoops, sorry, too far, that if you file a T visa, a VAWA self-petition, which I'll talk about, a U visa, those three forms of relief in particular, and continued presence, which is for trafficking victims, any of those forms of relief end up getting lodged in a computer system at the Department of Homeland Security designed to stop the Department of Homeland Security from relying on tips from abusers, and that requires them to keep the information contained in the records confidential so that they can't be released through family court discovery, criminal court discovery, or any other means to a potential perpetrator. There are VAWA confidentiality protections as well against courthouse enforcement, against victims, and there is an ICE policy that was released in February of 2018, I believe, that says that, that confirms that no immigration enforcement should be taking place in family or civil courtrooms or cases. So any of the cases that would involve an immigrant child abuse victim or immigrant child is a victim of neglect, any of those child welfare proceedings, custody, etc., there should not be immigration enforcement occurring in those courtrooms. And we have a whole separate webinar we can make available to you that talks about the courthouse enforcement and immigration. So what's also important to understand is that once a victim, a child abuse victim, or an adult victim, or a parent that is of an abused child begins the process of applying for immigration relief, they get protection from deportation. They get the VAWA confidentiality protections I was just talking about. They get it enhances safety for survivors. It puts them on a path to temporary and often ultimately permanent legal immigration status. We'll be talking a lot about how family members can include, like when a child files, they can include their parent in their application. Where an adult files, they can include their child in their application. And it also promotes financial independence from the perpetrator because it puts people on a path to legal work authorization, and it gives them, as we'll be talking at the end of the webinar, greater access to benefits. So Judge Collins, when litigants and their children learn about and pursue immigration relief legally available to them, how might this improve access to justice in the family courts?
Well, it's really important that we make sure that their rights are protected. I mean, that's what our role is as judges, to make sure the rights of our litigants are protected. One of the things that we know is that if they feel that they can't get into the courts or at all, or if they will be, if they will have immigration authorities swooping them up if they go to court, then they're less likely to avail themselves of their legal rights. So we want to make sure that people who have legal rights know about them, know how to exercise them, and know that when they come into the courthouse, they have the right to come to court and use it. We have a lot of children who are victims of crime, who may be crime witnesses. They are important to our system to make sure that we can protect the safety not only of them, but also the safety of the community. Access to the courts is a big deal, and we really take it seriously. So it's very important that we know, that they know what their rights are. And part of that is making sure that we as judges do what we need to do. And that's because if we don't make detailed findings in our order, then they aren't going to be able to use that to explain to the authorities what our ruling actually was. So when you have a judicial order, you need to make sure that you include in there what the family relationship is. Don't just take it for granted that somebody knows that this is in fact the son or the stepson or the stepdaughter or the daughter of the abuser. You need to put that in there. You need to make sure that you put in what the relationship is, if they were married or not. You also need to put in what the abuse was. Was it battering? Was it child abuse? Whatever it was, you need to make sure that you spell it out, and spell out what the specifics act for that give you that conclusion. And you have to cite what your state law is that you're using. So make sure you put in there, according to state statute, and then put what the statute is, what you're using. This is common for us. This is what we do in every order, really. So it's something we do. And the reason that we are doing this is because Congress felt like we, as judges, were the experts in child custody, child dependency. In cases that involve children, we deal with them all the time. So they didn't want to redo these things. They wanted us to hear it, to make those decisions, and then to tell them what our decisions were. And it's important that the people who come in our system.
Rosemary, you're breaking up.
Oh, okay. Is that better?
Yes.
I don't know what happened. Okay. I think I put my arm over the speaker. One of the ways that you can make sure people know what your rights are is to distribute the Homeland Security brochure, Know Your Rights. So there are many different ways. This is one of the ways. Make sure you make sure advocates and attorneys know what their rights are, but also have printed materials there for people to use so that it can help inform them and lead them to the direction so they can exercise the rights which they legally have.
And the Know Your Rights brochures are on the web link, and they're on the PDF materials guide for you, so you can download them directly from there, and they're also available in multiple languages. And I just want to also add that Congress, there are two places for court that where judges sitting in cases, hearing cases regarding children, where Congress has delegated to them a role in the context of U and T visa certification, which we'll be talking about in a minute, and in the context of special immigrant juvenile findings, where there's a role in the immigration process explicitly for state court judges hearing cases involving children. So let me just start very briefly to just explain the major forms of immigration relief so you can be able to recognize them in the cases that you're working on. First is something called a VAWA, Violence Against Women Act self-petition, and this helps victims of domestic violence, spouse abuse, child abuse, and elder abuse cases. In the child abuse cases, it's when the parent is a U.S. citizen or lawful permanent resident, either parent or step-parent, or a U.S. citizen or lawful permanent resident spouse. And it can also cover elder abuse cases where the perpetrator is an over 21-year-old son or daughter. These are cases where basically they're family violence cases. Battery or extreme cruelty cover that definition under immigration law, covers what most state statutes would consider abuse or neglect. And so that's the primary form of relief when there's a U.S. citizen or lawful permanent resident perpetrator, spouse, or parent. In addition, there are remedies for victims of human trafficking, and some children that you may see in courts may be victims of either sex or labor trafficking, and that they may qualify for either the T visa and or continued presence. But the major forms of relief that you're most likely to see people who qualify for are the U visa and special immigrant juvenile status that Judge Collins is going to talk about now.
Yeah. What we see mostly is that we have victims who come into the court system, and they are a victim of what we call qualifying criminal activity, which we'll give you a slide on in just a second. What you need to do is make a determination and say that in your order that this person is a victim of a qualifying criminal activity, that they have been is being or is likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing. That's what we call the helpfulness part of it. That they've suffered substantial physical or mental abuse as a result of the victimization, that they possess information about the crime, and the crime incurred in the United States or violated U.S. law. And this is different from some other forms of relief where the crime may have occurred outside of the country, but this, for a U visa, the crime has to have occurred in the U.S. Or violated U.S. law. So it could be a crime outside the country if it violates U.S. law.
Right. So generally speaking, both the U visa and the trafficking victim T visa, the abuse would have had to occur in the United States. For the VAWA self-petitions, you could have a situation where somebody who works for a U.S. embassy or on a U.S. military base harms a family member, abuses one of their family members, let's say commits child abuse, while they're on a military base in Germany. That case could be filed from abroad, but not on the U visas.
Right. So when you talk about what a qualifying criminal activity, you can see almost anything that would qualify under, say, if you're going to get a domestic violence order of protection, that would be involved in this. But there are many other things that qualify. So there's a list of all the criminal activity, which can include involuntary servitude, false imprisonment, witness tampering, which we see a lot of times with victims who, that they are constantly badgered by the offenders, obstruction of justice. So, but the domestic violence, sexual assault, rape, incest, those are all in there, and they all are the criminal activity that qualifies for the U visa requirement. And of course, any attempt, conspiracy, or solicitation to commit those are also qualifying under the U visa definition.
And so on this case, what happens is that the immigration law definition of domestic violence is battering or extreme cruelty, and it covers, so that's where child abuse and elder abuse fall in this list. So, and that in extreme cruelty, you could also pick up many of the cases that courts might see on child neglect as well. And we actually have, as part of our Special Immigrant Juvenile Status Training Manual, lists where you can look up your state law and see what your state law definition is and how they intersect with these federal definitions. So what's really important to understand is that when you look at the U visa statute, or sometimes the forms that might be for the certification and other things, one of the things that DHS makes clear in its materials that it produces, and there's a resource guide on the materials list, they basically say, as do all of the regulations say, that investigation or prosecution in the statute always means detection or investigation or prosecution or conviction or sentencing. And it's criminal activity, not crime, because the goal is to identify victims early, whether or not there's a criminal case that's ever brought. So it doesn't require that there have been a criminal prosecution or a criminal case opened or a police report. Coming to court to get a protection order it can be enough for the court to detect the facts of abuse occurring in the family.
And it's important that we put in there in our orders that we issue, in whatever context the issue is coming before a judge, the judge has to put in there that they believe that the applicant is a victim of qualifying criminal activity, and that's just your personal belief. It doesn't have to be a conviction. It doesn't have to be that it was adjudicated. It can be that just your personal belief based upon the evidence that you're reviewing. You don't have to go out and do a personal investigation yourself. You just review the materials that have been presented to you, which can include the court file. It can include the request for the order of protection. It can include police reports if they've been submitted. You have to also include that the victim had knowledge of the criminal activity and that they was, is, or likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing, as Leslie just said. Doesn't have to be all of them, and their cooperation, can be it can be explained if they don't continue to cooperate with the, say, the pursuit of criminal charges. But if they have been helpful, then it is enough for the certification on this U visa.
Right, and what happens is the Department of Homeland Security, the regulations and the whole implementation and the statute in the U visa was designed with an understanding that particularly victims of domestic violence, sexual assault, stalking, human trafficking are often under threats from the perpetrator not to cooperate and may go back and forth in their levels of cooperation over time. What's important to know is the certification happens early, and then Department of Homeland Security adjudicates the case, and by the time the victim actually receives the visa, many of these victims, even though maybe they were hesitant in the beginning, ultimately gain more confidence in the system and begin to cooperate over time. And they have an opportunity, they have to show before they can get their visa that they either cooperated or didn't unreasonably refuse to cooperate. Judge Collins, in what types of court proceedings might a judge detect helpfulness?
Well, it can come up in a wide range of court proceedings, not only in family court, where you have almost every type of case in family court that it can come up. Juvenile court, criminal court, probate court. I think a lot of people don't think about it in probate court, but it can come up there, and it can come up in civil cases, employment cases, or if you have other cases that come up. So it can come up in a wide range, and it doesn't matter where it comes up. And so it's no magic. It doesn't have to come up in a criminal case or in a civil protection order. It can come up in any one of these cases. And so any judge hearing any of these cases can certify because they have the facts before them or about the facts that were brought in a particular type of case.
And one of the things I think in child abuse cases that's really important to understand is you might have a child who is being abused in a family, and that could either be the natural child of an immigrant mother, or it could be the stepchild of an immigrant mother, and that the way the law is structured, if the child is a citizen and being abused, but the mother, who is the non-abusive parent, comes forward and brings the child to court for a child welfare proceeding, or seeks a protection order and includes the child in the protection order, or raises the abuse of the child in a custody case, that's helpfulness, and that parent is eligible for the U visa whether or not that parent was abused themselves as well.
Right. So why might an immigrant child victim or parent come to you for certification? So if you could just fill this out, there's the box there with potential answers, or if you want to write in the chat box, you could go ahead and do it. Here we go.
People are voting. I'll give you a few minutes. So it looks like most people are saying that if the child or parent sought a protection order, that the judge could certify. They could come to court for certify. Somebody else is saying a couple of people are saying if they provided evidence in a child welfare proceeding, and that some people might come in some kind of civil or family court case, and they've maybe evidence in the record that they called the police for help, but there wasn't language access at the crime scene. So, and then many of you are saying all of the above. And the correct answer is all of the above, that any of those could be scenarios where a judge could sign a certification. Sometimes you'll see evidence of having called the police for help in the civil case or criminal case you're hearing, but in many other times it's just providing the evidence in the child welfare case or seeking a protection order is sufficient.
And it can come up, like I said, it can come up in cases where you might not expect it. If you have a juvenile case, there could be evidence brought out that the parent is abusive and or that the child was a victim of this type of crime, and that absolutely can be used.
Okay. So on to special immigrant juvenile status.
Well, this is as Leslie was saying earlier, this is one of the circumstances that Congress did carve out a specific role for the courts. And in fact, we are the gatekeeper for special immigrant juvenile status. You have to go to court for the special immigrant juvenile status. And the reason Congress did that is much what I said earlier, that they know that courts deal with juveniles all the time, that we have an expertise in children, and they wanted to make sure that the people who knew the most about how to handle child-related cases were the ones making these decisions. So the special immigrant juvenile status was designed to provide immigration relief for unmarried children who are under the age of majority under state law. So make sure you check your state law about what that is, and understand that when they're under the age of majority, that means that it has to be done before then. So it's important that this relief, if children are available or are eligible for this relief, that you get them in as soon as possible to apply for the special immigrant juvenile status finding. Because if they age out, then they can no longer get this relief, even though they might qualify because they are a victim of abuse, abandonment, neglect, or dependency by at least one parent. And it doesn't have to be both parents. You can have a protective parent, but if one parent is abused or abandoned or neglected them, then that is enough. And you must have the required findings from a state court judge with jurisdiction over the care, custody, and dependency of the child. And as I said, Congress wanted us to make this because this is our expertise. We regularly adjudicate facts of child abuse, neglect, and abandonment, and we regularly issue orders regarding child care, custody, and placement. So this is something that we are experts in and that we do all the time, and certainly are comfortable with this role as judges in juvenile court or in any court where we deal with children.
So what are the kinds of courts make in these? No, I was just asking you, Judge Collins, can you tell us about the explicit findings that judges need to make in these cases?
Well, it goes back to pretty much what we said before. You want to make explicit findings as to the identification of the individuals. We want to make sure that you say what their relationship is. Make sure that you say it's what that relationship of the abusive parent is to the child. You also have to say that you have jurisdiction over this child, so make sure you say how you have jurisdiction over that child and what capacity, and that you have to make a finding that it's not in the child's best interest to return to their home country, and that reunification of the child is not viable with that parent due to at least one parent's abuse, abandonment, or neglect. So that's what you have to put in your order. These findings, you also must say who's going to be the custodian, and that can be the non-abusive parent. You can say where the child will live, and you can say whether the child will be committed to the custody of the state or private agency for care, custody, treatment, or rehabilitation. Now, as long as the case is in front of you, then you have custody of that case. So that's, you know, our juvenile cases, as you know, go on forever. So you have that case. And these cases, these issues can arise in a whole variety of areas, including the civil protection orders that many of you identified, the custody cases, divorce cases, guardianship cases, delinquency cases. So it's available in a wide range of types of cases involving juveniles.
Oh, yeah.
When you're,
sorry,
go ahead.
No, you're right. Go ahead.
When you're making the decision about the home country is not in the child's best interest. Now that sounds like it could be tricky, but it's really not. You don't have to go to another country and make your own factual determination of what the situation is in that country. Really what you're doing is the same thing you do in almost every case where you make a decision about where you're placing a child. You're saying where the best interest of the child to be placed. And so you're saying the best interest of the child may be placed with mom here or with aunt here or uncle here because there is no decent or no appropriate custodian back in the home country. You apply your own state law. You don't have to figure out what the state law is or what the law is in another country. You apply your own state law, and you do the same kind of findings that you always do, the best factors findings, making why under that best factor umbrella, you're not choosing placement in the home country. And you can consider factors like the child's performance in the school, the child's medical situation. They can get great medical care where they are. They may have established relationships with other children. They may be on teams. So it's pretty much the same kind of distinction that you're making in every case when you decide where you're going to place the child. So you can talk about the support, helps, and services that the child may need and versus what you have evidence of from the home country.
And what I think is important with this is that, you know, we're talking about children who've been victims of child abuse, abandonment, and neglect. And so they may have delays in development related to trauma and how trauma they've suffered affect their brain development and their physical and mental development can be delayed because of it. And so you can identify those factors if they have special needs that may be met, that are being met in the community where the child is now, but might not be able to be met in the home country. We have a tool in the materials list that there are extreme hardship factors in the VAWA, in some Violence Against Women Act cases. There's immigration laws in which they have these country comparisons that might provide a useful checklist of factors that you might look at and put in your order to illustrate why it's not in this child's best interest to return to their home country.
So the why it's in the best interest for the child to stay here, as I said, is the same kind of determination that you usually use, and that's the same thing with reunification. Because with reunification, you have to include the finding that why the reunification with the abusive parent is not viable. It could be because they've abandoned the child. It could be because they haven't evidenced any interest in the child. It could be because they're causing the child harm. But you have to include why you're making that decision. You can't just come with a conclusion. You must actually say why you're doing it. And under your state best interest law, you must identify the factual reasons why this reunification is not viable, which can be why you're saying that the abusive parent is not being granted physical custody of the child. And this is important, and it's the same standard we use in all cases, because in any case, you want to make sure you make those rulings on the record, because if you're granting custody to mom because there's an abusive parent, and mom goes out and gets hit by a car outside of the courthouse, you don't want to have to go back and do a rehearing about why dad might not be fit. If you have the evidence that dad's not fit, you need to put it in to the record at that time so that that child is protected no matter what happens with the caretaker that is walking out with the child. And
one of the things I think, the last thing I want to note on special immigrant juvenile status is that this is a case, in many cases that the courts see, you may have both domestic violence and child abuse occurring in the same family. So the father or mother, but the perpetrator of domestic violence in the relationship may be abusing their either the spouse or the other parent, the intimate partner, and they may be also abusing the child. So going back to what's also important to understand with these various different forms of immigration relief is they have different adjudication times. So from beginning to end of a special immigrant juvenile status case takes about 3 years right now. VAWA self-petitions take about 18 months. The U visa entire process takes over 14 years. So you could have children that qualify for U visas, but also qualify for VAWA for special immigrant juvenile status. And mom may file for a U visa, but her child may apply for special immigrant juvenile status in addition to being included in mom's U visa, because the child's case will move faster as a special immigrant juvenile status case than a U visa case. And the point I want to make here is that in each of these kinds of relief, there are different people who can apply. So that in a VAWA self-petition, it could be the abused child or the parent of an abused child, or where they're both abused, the abused parent applies and includes the abused child. So you could do that. In a U visa case and a T visa case, you have to divide what family members can be included changes by whether or not the applicant is over or under the age of 21. And what's really important about these cases is if you have siblings at risk, that the siblings can get covered in the U visa and T visa cases sometimes better than they might be able to be covered in the VAWA self-petition. Special immigrant juvenile status is the child only. No siblings, no family members, no parents. So there are big differences between those three different kinds of cases. The other thing I want to mention as we kind of bring this discussion towards the close of the immigration relief part is that divorce in a family that involves immigrants, and particularly in a family that involves a child abuse victim, isn't benign. And what I mean by that is if there's a divorce before, let's say you have a case where a child who's a stepchild of the abusive parent is being abused, divorce will cut off the ability of that child to self-petition. In a family-based visa petition, the other thing about the self-petition is if they file the self-petition before divorce, the divorce can happen and it doesn't affect the case. However, if you've got a family before you where, let's say, the father is applying for a green card and included in the family members, divorce prior to each of those family members receiving the green card permanently cuts them off, including the child. Divorce after they receive their green card doesn't cut them off they don't lose their green card. So it's important just to understand how that works. So what we're going to, each of these forms of immigration relief brings with it protection from deportation, a path to legal work authorization, which is the point at which in many states crime victims will receive driver's licenses, and that they bring some additional access to public benefits beyond what is available to anybody without regard to immigration status, plus the VAWA confidentiality protection that I was discussing before. So what we're going to do now is I'm going to read you a case, and then we're going to ask you a few quick questions, and this will give you an idea of how these cases play out in court cases involving immigrant children. So Clara and Eduardo met. Clara met Eduardo, who's a naturalized citizen, when he was back visiting his hometown in El Salvador. They began dating, and Clara, who was raising while Clara was raising a 9-year-old son, Miguel, by another relationship. After Clara became pregnant and gave birth to a baby girl, Lupe, Eduardo decided to bring Clara, Miguel, and Lupe to the United States to live with him. When they arrived in the United States, Eduardo took Clara and Miguel and Lupe's passports and became physically and sexually abusive of Clara and abusive to Miguel when he tried to protect his mother from Eduardo's abuse. Eduardo also physically beat Lupe, the little baby, when she misbehaved. Within a year following their arrival to the United States, Eduardo forced both Clara and Miguel to work for his family business and never paid them for their labor. One night when Miguel was 13 and Lupe was 5, Eduardo's rage led to severe beatings with a belt of Miguel and Lupe. When Clara intervened to protect the children, Eduardo strangled her until she passed out. Neighbors called the police. Clara talked to the police when they arrived. The police arrested Eduardo for attempted murder and child abuse and took Clara to the hospital, placed the children in the care of the state.
So what we'd like you to do now is check and tell us what forms of immigration relief would Lupe and Miguel qualify for. Just Lupe and Miguel.
A couple of minutes to think about this. Okay, so we're getting some mixed results. So many of you think that both Miguel and Lupe can self-petition. So Lupe can definitely self-petition because she was abused by her citizen father. Miguel, however, is the son of Clara, and we don't know if there's a marriage. If there's a marriage, he's the stepson and he qualifies to self-petition, but if there's no marriage, he doesn't qualify. Both children qualify for a U visa, but as I said, the U visa case could take 14 years. The self-petition is a year and a half. And you guys all got that one right, that Lupe doesn't actually qualify for a T visa because she wasn't the one that was trafficked. So when Eduardo forced Miguel to work and not pay him for his work, that could be basis for a T visa for Miguel. So the correct answer here is that they both qualify for U visa. And in addition, Lupe could self-petition and Miguel could follow for a T visa. Next one.
Okay, so let's talk about Clara. What kind of immigration relief would Clara qualify for?
We're seeing a few people respond. Okay, it looks like people are getting this right. It is true. It's all of the above is the correct answer. She qualifies for a U visa because of the abuse she suffered. She qualifies for a VAWA self-petition because she's the parent of Lupe, and she qualifies for a T visa because she was forced to work and not paid for her labor. Excellent.
So how would what immigration Clara files make a difference in the help that the children receive, Leslie?
So what happens is that, as I showed you in the slide earlier, sometimes, in some cases like the U visa, if Lupe files, she could include her sibling Miguel. So the question in this case, if it came to me as an immigration case, I would want to look at the forms of relief that Clara could file for, the kids could file for, that would give them all access to relief as soon as possible. And in this case, because Clara was a victim of human trafficking, and those cases proceed quite quickly, and so was Miguel, if Clara filed for a human trafficking case, she could include Miguel and Lupe in her application, and Lupe could independently file for a self-petition. But Miguel couldn't be included in that self-petition, and those are the kinds of things you have to kind of figure out But there are protection. They allow protective parents to get the help they need. So now for the remaining part of the webinar, we're going to talk a little bit about protection orders, custody, and the public benefits that immigrant children and who are victims of abuse and neglect and crime victims and who have parents who are helping to protect them or who are crime victims can receive. Ms. Collins, what types of protection order findings from your experience have you found are helpful to children and immigrant children as we're discussing on this webinar?
Well, it's important that we specify, again, what the relationship is. That's normal in protections order. We usually have to say that. Sometimes we don't specify the relationship of the children. They may be included, but it's important that you put in if that's a stepchild or a natural child or what the relationship is. It's also important that you put in what the actual behavior is, not just say there was abuse, but spell it out and say that whatever they actually did, which constitutes abuse, that you spell that out in your findings. So they specifically refer to that child and that child's abuse. It can be, interfering with the parental responsibility of the mother. It can be specific that caused the child to be neglected because he did this or he did that, or he refused to let her have the car to take the child to the medical appointments that the child needed. Whatever it is, you need to be specific about what the facts are so that it's clear for people who are looking at the order later what your findings were. The Immigrants and Protections Order, you should understand that it doesn't matter what the immigration status is of the party or the child for people to get civil protection orders. That has no effect on whether or not they can receive it. And the protection order issuance has no effect on immigration status. So if a party comes in and says you can't issue an order of protection against this this party because he will lose his ability to get immigration status in the country, and then he can't support the children. The issuance of an order of protection does not affect immigration status. The violation of an order of protection does. So that's a great opportunity to explain that to the offender so that way they know as long as they don't violate the order, that won't have any basis for immigration status to change just because of the issuance of that. And they often need creative protection remedies using the state catch-all provisions. So it's important that you look at creative ways that you can stop immigration-related abuse, such as turning over documents, making sure that they have the ability to move on with their lives, get the child support. If you bring in children or a family into this country, you have to file an affidavit of support showing that you are able to support them. They're very detailed documents and can be used by you to set child support. So they're very important. And health insurance, that's always very important for any family. So you can use your remedies section to make sure that the immigration remedies are covered in that, and so the child gets the relief that they're entitled to because they have access to the documents they need.
And then there's issues that come up in custody cases involving immigrant children who may themselves be victims of child abuse and neglect as well. And one of the things that we just want to kind of start this section off is to note that the social science research about helping shows that when there's co-occurrence of domestic violence and child abuse in a relationship, or there's just domestic violence in this relationship, that immigrant victims who receive help through protection orders or begin to get immigration relief, that those help-seeking battered immigrant women, we see a dramatic drop in the co-occurrence of child abuse in those families and in those relationships. These are cases where we've actually been able to see in the social science data that protecting mom actually does protect the child as well, and is very important to remember when you're addressing these kinds of cases in child custody proceedings. Judge Collins?
So often when you have a case, people will want to bring up immigration status to show that that person is not a good caretaker, that they can't take care of the child, they won't be able to take the child to medical appointments, things of that nature. And it's important that you understand that immigration status is not relevant to things that we consider when we're making a determination about custody. So it doesn't matter if I'm an immigrant or not. What matters is my parenting skills, how best I am able to protect and take care of a child. You use your best interest standards, and you look at what your statute says regarding custody awards to non-abusive parents, because many states have provisions in their laws that say if a parent is committing domestic violence, that certainly is a factor to be considered when you're ordering custody. It can be relevant to the abuse because if somebody is saying, if you go after me in court, then I'm going to tear up your documents, I'm not going to file for immigration relief for you, I'm going to turn you in for deportation, which we know happens all the time. These threats are used to silence victims of crime and can often be part of the history of violence. So it can be relevant to that kind of information, but certainly not relevant to your skills as a parent or your ability to provide the best care for your child. There are many things that people bring up in courts that it's important you know what's true and what's not true. Because abusers will say she's going to be deported right away or he's going to be deported right away, and the DHS policy says no, that's not true. Many times people will say that she's going to flee with the child if you give her custody, but it's really interesting to look at the social science that shows that U.S. citizens and lawful permanent residents are the ones most likely to flee with their children, especially when there's been threats of kidnapping. They're dual nationals, and they can travel freely to and from the U.S. They often have more resources and are able to do that, and the cases really support that it's really the U.S. citizen or lawful permanent residents that often flee with the children, not the one who wants to stay here. The parent has no livelihood, but they have a path to work authorization and benefits, and they are entitled to child support in most cases. And often they say, I can't file for benefits for my child if I don't have custody of this child. But that's not true either. Custody does not affect a parent's ability to file or get immigration benefits for the children.
So, and what's also important to understand is perpetrators of domestic violence in particular and child abuse will come to the court and say, well, I need to get custody. Maybe I'm an abuser, but I need to get custody because she's going to be deported. And so we pulled together the data from the Department of Homeland Security, from Immigration and Customs Enforcement, that shows that these are the groups of people that are most likely to have a deportation risk. Generally speaking, as you can see consistently, historically, it's people who have criminal convictions. Currently, if somebody has an open criminal case against them, then there might be some risk of removal for that person, or somebody who has an order of deportation that's already been issued against you. The vast majority of people that are coming before the court in custody cases are not in this position. And sometimes what we see often is that once the perpetrator is served with papers in the custody or the protection order case, he may run off and try to get immigration to pick up the victim. And that's the trigger, but that's not a trigger that, according to this data, or generally speaking, is going to actually result in him or her being removed. This is a case that I bring to your attention because it was an excellent decision, unanimous decision by the Nebraska Supreme Court in a child welfare termination of parental rights proceeding, in which they confirm that absent unfitness, that immigration status isn't what determines fitness or unfitness, that all families have the right, parents and children, to a constitutionally protected right of the parent-child relationship being protected, and that applies equally to undocumented immigrants, to immigrants who might be in the process of applying for immigration relief, to people who've been in immigration detention, and people who've been deported. And this was a case in which the children were wrongly taken away from a woman who was trying to care for her children but didn't speak English, and they never gave her an interpreter in her language and ended up cutting off or terminating her parental rights. And the court said they can't do a comparison of whether it's better to be in the U.S. with an adoptive parent than to be with a natural parent who is a fit parent in Guatemala. And so it's a good case that I recommend that you look at. And out of that came that victim, the parent in that case was in DHS detention and was never brought to the child welfare proceedings or given notice of them. And so DHS now has a policy in place in which they, with directions about how courts and attorneys and advocates and child welfare agencies can make sure that parents can get to court in the cases that their children are involved with. So we're going to conclude this webinar with a brief discussion and connection for you to information about what kinds of publicly funded benefits and services are available to immigrant children and who are victims of child abuse and neglect, and to their parents who may be victims of crime. Judge Collins, why might that information be important to families, to the courts when they're working with families that involve child abuse and neglect?
Well, it's really important for us to know how that a child's going to be taken care of. So it's important to know what kind of public benefits are available so that we can make sure that the child welfare is taken care of. And it'll help us make decisions about child support. It'll help us make decisions about the best place for the child to reside, because there may be benefits available here that are not available, say, in the home country. And so it's really important for every aspect of your child to know what kind of benefits are available and how they can access them.
And we're getting close to the end of the webinar, so I'm going to do this quickly, but these are all in the materials, and we will send you, we have your email addresses, we'll send you the link to this material on the web. But basically, there's a wide range of services that you can see on this list that are available to anyone without regard to their immigration status, documented, undocumented, victim, not a victim, that are available to everyone. In addition, there are services, any services that are necessary to protect life and safety are available to everyone without regard to immigration status, as are public, secondary and elementary education, school lunch programs, and emergency Medicaid, and that it's also important to note that when a child qualifies for benefits, let's say a citizen or lawful permanent resident child, and the parent who may be undocumented can come and make the application for benefits the child qualifies for without being asked any questions about the parent's immigration status or social security number. And we have lots of information on this. In addition, as I mentioned in the beginning of the webinar, when people begin to apply for legal immigration status, their access to public benefits grows. They gain particular access to public and assisted housing, post-secondary education, subsidized child care, driver's licenses, adoption assistance, foster care, things like that. People can be paid as foster parents. But there are other benefits, these listed here, TANF, SSI, food stamps, and medical health subsidies that are harder to get depending on the immigration status. So what we've done is we've developed tools that you can use, that you can go online and see in your state what the victim that is before you in the court could qualify for, and that you can look it up by public benefit. Here's a list of the benefits that we have state maps on, and that if you have a victim that qualifies for, let's say, TANF in your state, or legal, or Medicaid, or any of the food stamps, you can then, each of the charts, the maps, click to a chart with all of the detailed information based on immigration status. So you can see the difference between a VAWA self-petitioner, a T visa, SIJ, U visas, and you can then, this is loaded with footnotes, and you can get the footnotes linked to the laws, the regulations, and the policies and the websites in your state that you can take into the Child Welfare Agency when a victim is applying. So I'm going to, go ahead, Judge Collins.
Yeah, no, I was just going to say, make sure you look at the attached form, Legal Rights of Immigrant Children webinar materials. That has a ton of material that is very helpful, and it helps you pull out what you need when you need it.
And so we have one more upcoming webinar in this series that's co-sponsored by the National Council of Juvenile Family Court Judges and NUAP. And all of the prior webinars in this series are links, contained in links in the materials we're handing out and that we will send you. And you can always call us for technical assistance, and the council, if you're a court, for technical assistance. And we can assist you with an individual case that you're working on and guiding you to the right information and materials. Thank you so much for joining us today. Thank you, Judge Collins, for your great help presenting. And I will turn it back over to Alicia at the council.
Thanks, everybody.
Thank you all for joining us. We're going to close out the webinar now. I see a few last-minute comments coming in. So if we don't see any questions from that, we'll close out. Thank you.
And please fill out the evaluations.